Okay, good morning, everyone, and welcome to our webinar talk and panel discussion entitled Unlocking the Next Level of Compliance with AI. My name is Imran Qureshi, and I am a partner in DLA's Edmonton office. I am also a member of DLA's Canadian Corporate Crime Compliance and Investigations Group. By way of background, I am a trial lawyer, and my practice focuses on advice and advocacy in corporate and commercial litigation with a focus on shareholder and directors disputes, corporate oppression, fraud, and emergency injunctions. I will be moderating today's discussion, and I'm joined by quite an esteemed group that I can roughly divide into two groups. And those two groups are people that have worked for the CIA and those that haven't. Okay, so if we can get maybe the slides going, and I want to introduce this esteemed panel that I'm joined by. So we have first and foremost Mr. Bennett Borden, and he is a partner with DLA based out of the Washington, D.C. office. He is also DLA's chief data scientist. He's an industry leader in forensic AI and algorithmic bias testing. Bennett leads DLA's artificial intelligence and data analytics practice, and their team offers a number of combined legal computational services, including auditing clients, AI for algorithmic fairness and regulatory compliance, creation of AI-enabled tools to help clients leverage data, and intelligence-style enhanced e-discovery analytics team for next-generation litigation and investigation. And as I alluded to earlier, Bennett has worked with the CIA. So if any of you are watching this WebEx stream in your pajamas, just know that he can see you. Okay, I'm just kidding. Okay, moving along with the introductions, but staying in the United States, we have Brian Benjet, and he is a partner with DLA in their Philadelphia office and a co-chair of DLA's global compliance practice. Brian assists both public and private companies around the world in designing and implementing risk-based compliance programs. These include conducting risk assessments, drafting codes of ethics and related policies, conducting compliance audits, and creating and implementing training programs. He provides advice on governance issues and operational risks to boards of directors, auditors, investors, and potential M&A partners. And finally, in Vancouver, British Columbia, we have Ryan Black, who is also a partner with DLA and practices technology-related business law with a particular focus on information technology, video games, and esports, as well as intellectual property and internet-facing businesses. Ryan has expertise in emerging technology matters important to today's businesses, such as cybersecurity, artificial intelligence, blockchain technologies, or open source software, deepfakes, cloud computing, and social media. So a warm welcome to all of you, and thank you for joining us today. For the benefit of our viewers and attendees, I'm going to provide a quick outline of our discussion topics and agenda, and then I will quickly hand over the reins to Bennett. So we will begin with Bennett, who will walk us through some fundamentals for understanding generative AI and automated decision-making. I've heard Bennett speak on these topics before, and I can say rarely have I heard such a lucid and plain language explanation of otherwise very technical concepts. So looking forward to that. And after providing a background on that and identifying some risks with generative AI, our discussion will turn to regulatory trends in AI, which will be led by Brian. And then Bennett will also, I think, come back in with some additional information on international policy initiatives. We will then jump over to the Canadian context and examine the Canadian legislative developments. That will be a discussion that will be led by Ryan. Finally, we will circle back to Bennett, who will talk to us about some additional governance issues and use cases. If you have any questions, please use the chat or the Q&A function. We'll be moderating that, and based on time and relevance, we will do our best to attend to those questions at the end of the formal component of the webinar. And so with that, I will hand it over to Bennett.
Thank you very much, and thanks for joining us today. This is a very interesting topic. We are of the opinion that AI and generative AI is one of the most transformative technologies we've seen in 100 years, and it has immense potential, but it also carries with it risks, as with any new technology. And so we thought we'd start by um, kind of a level setting exercise. If you think about AI that we run into in the world, they fall into two buckets. About 99.9% of the AI out there are really algorithms. They're these algorithm classification systems. So think when you apply for a mortgage or a credit card, a loan, insurance, what you see on your social media feed, the advertisements that you see, even what gets recommended to you when you check out at an online shopping and it says, hey, you might like these things too. All of these narrow AI systems, and they call them narrow because they do one thing. I'm trying to figure out whether you're going to fit, you have a good fit for this job, or what your insurance risk is, or what you're going to click on. And so all of these narrow systems, these classification or recommendation systems, they all kind of work the same way. They are taking a whole population of people and then running them through a machine to kind of break them into groups. And the people in the groups are similar enough that I can take some decision or take some action or make a decision based on that group membership. The way that I describe it is it's almost like a giant Plinko machine. I don't know if you guys remember the Plinko game where you put a disc at the top and it kind of bounces through all these gates, ding, 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 and it ends up in some group at the bottom. That's pretty much how these systems work. If you think about what every one of these gates are in the Plinko machine, they are data points and they have a threshold about you. And the whole point is to divide this big population into smaller and smaller groups to answer a very specific question. They're trying to find a characteristic that they care about. So think I go online and I apply for life insurance. And so I put some information about me, my name, my age, gender, address, my medical history, and I push the button, and the insurance company gathers more data points or information on me. Think your prescription history, the diagnostic codes in your electronic health record, sometimes your credit report, your driving record, your court records. And each one of those data points gets pulled in and acts as a little gate. So think everybody's in a big group, and the first division is gender, men versus women. Then you've got age brackets, and then weight brackets, and then all these other data points. And all of this, again, is meant to put you into a group where we can take some action based on that group membership. And different industries care about different key characteristics about you, right? So they're looking for this one answer that they can make a decision on. And so every industry has a different characteristic or a set of characteristics that they are trying to identify through these data points or variables about you. The issue with these systems, they're very good and they're very accurate, but they're also kind of a simplification of reality or a caricature of the truth. I can't build a model that has every single data point on every single person. Like I can't actually model reality. And I don't really care to. Most of the time, I'm looking for, again, a very specific characteristic. So, because I am simplifying the truth, reality, then it is always my simplification is going to introduce error or inaccuracy. And this is what we call bias, right? And I mean bias in a scientific sense, meaning there's something inaccurate about my model's view on the world. Sometimes that scientific bias can turn into illegal bias or discrimination. We'll talk a little bit about that. So the way there's actually this very famous saying by one of the fathers of data science, Dr. Robert Coase in the UK. And he said, all models are wrong, but some of them are useful. And that's really the kind of the thing to think going in. We as business leaders need to understand how these narrow AI systems can be very useful, but they just come with some risks. And so the risks that these typically produce come in three buckets. One is the data that goes into the model to build the model. The second way is how the model itself works. And this is really around what data points am I choosing for my gates, and then what thresholds am I using on that data point. And the third is the output. How am I using it? These models work, like the science is very solid. You feed it in, it builds a model, it gets an answer. But how we take that output and decisions we make based on that can be a problem. So let me just give you some little examples about this. On the data that comes in, most of the data that we have about human behavior comes from people's participation in the digital economy. So think smartphones, social media, online transactions, key card swipes, apps that we use, loyalty programs, and all of that data skews toward populations that participate in the digital economy. But there are giant swaths of the US and world population that does not participate to the same degree as other people, which means that our data is over enriched for some people and under enriched for others. That's not a problem. Any data scientist knows that that's just the reality of things. Where companies run into trouble is when they don't look for that imbalance and correct for it mathematically. This is especially true in like life sciences, healthcare, pharmaceutical, because most of the data we have about people who interact with the healthcare system are from people who interact with the healthcare system. Well, that skews toward people who have insurance, a job, stability, access to education or nutrition, lack of food deserts, things like that. And so it's we often the question you have to ask yourself as a business leader when your company wants to build models like this is where did the data come from? Who's in it, who's not in it, and how can I look for that imbalance and how do I balance it out? The second issue comes with these thresholds. So the how the model works itself. Let me give you an example. So in the US, driving record data is complex because in the United States, non-white people get pulled over about 3 times more than white people do. It's just proven. So what that means is if I'm looking at somebody's driving record or the number of tickets, violations, then my data is 3 times over enriched for one part of the population than another part of the population. If I just come up with a score, these people are always going to seem more risky than these people, which is not an actual view of the of reality, right? So one is balancing that data. If my threshold is set at some absolute point, what I'm doing is I'm introducing unintended bias into my model, which can lead to unlawful bias or discrimination. So it's important to understand that the risks of these classification or recommendation, the old fashioned AI as of 10 months ago, is the accuracy of the data, the thresholds, the output, and then this bias issue. And so it's important to think through governing or controlling, looking for those risks. Then we get into generative AI. Generative AI is amazing. And it's probably the world's largest compendium of knowledge that we've ever created as a species. And accessing it is very interesting. The way that these things work is they're also a model, right? So for the text-based ones, they're built on large language models. We've heard this a lot, right? Well, what is that? It's a model of language built on a lot of stuff, a large amount of stuff. So what it's the way that they've created these is by feeding these LLMs trillions of examples of how human beings have gone about expressing an idea in writing. And these examples are from everything that was digitized over the last 60 years. So books, scientific journals, magazines, scholarly articles, all that kind of stuff, but also like people's Facebook pages and websites and Wikipedia and all those things, right? And so, one, it's important to understand that there's a lot of stuff. This thing has been sent to like World College, and its brain has been fed with some stuff that is correct and factually based and kind and accurate, and a whole lot of it's just not, but all of it's in its brain. The issue with Gen AI, the risks that this amazing technology um, produces, one is that to understand that all it's doing is predicting the next best word in a sentence. So its model of language. So if I said, hey, what's the best thing about AI? And it says the best thing about AI is its ability to, and then it knows what words typically come next in that sentence. You can see some percentages here. And so it picks what it thinks is the next best word and then recalculates what's the next best word, recalculates and on and on and on at a really amazing feat of technology. But the problem is it does not understand the meaning of those words. So that's why because it doesn't understand the meaning of words, it doesn't have a concept of truth versus falsity. That concept isn't embedded in the language. This is why it hallucinates, right? And you can get it to write anything. Just like I can walk up to a kid and say, hey, tell me a story. And they might tell me a story about a dragon, which is completely false, or about their dog, which may be true or false. But the point is, what I ask is incredibly important to what I get out. It's also important to understand that this applies to images, video, audio as well. Just as inaccuracy can show up in text, it can show up in pictures. And so it's really important to understand the power of this technology, but the risks that it introduces that you need to look for and guard for. One is accuracy, and different than the recommendation system's accuracy. This is about, is the stuff that's spitting out actually factually true or not? Well, if in some use cases, it doesn't really matter. Like if I'm coming up with stories or marketing lines or ideas or like kind of free flowing ideation, then accuracy isn't as important. If I'm a lawyer submitting a document to a court with cases in it, it's probably good that those be accurate and true. So the thing to understand is the more that accuracy matters in your use case, the more controls you have around checking to make sure it's accurate. The other issue is with IP. So a lot of our clients are concerned about, hey, if I put my confidential information into prompts, well, what's the legal effect of that? So it depends on two things. With consumer facing Gen AI tools, so I just go and Bennett, Borden, I sign up for a $20 a month account. There's very little protection in that. You don't own the input, you don't own the output. Your data is used to train the next model. Your data that you put in is intermingled with other people's, right? So all of that is a concern around consumer facing versions. Enterprise licensed version, the opposite are true. You own the input, you own the output, your data is never commingled, your data is not used to train the next generation of the model. The third risk is bias, and this is a little bit different kind of bias. Remember that everything that's been shoved into this thing's head, right? Some of it is not nice, not accurate, does not represent the values of your company. And so when it spits out something, you just need to have a control around it. And it doesn't have to be just like hate speech, but think with an image generation system, if you say, hey, show me 10 pictures of a lawyer, 8 out of 10 are going to be men. If I say, hey, show me a picture of a teacher, 8 out of 10 are going to be women. So just look for that kind of bias because it's in its brain. And so it's up to us to be able to look for that to make sure that that content represents the company. So with that background, I will turn it over to Brian to talk about what are we seeing developments in regulation around AI.
Yeah, thank you, Bennett. And I'm glad you did the first part because you can explain it a hell of a lot better than me in an understandable way. When we talk about sort of where we are, and I'm going to start from a very American perspective, being American, even though this is a Canadian audience. When we start to look at what's happening with AI in Washington and from a federal level in the United States, I think it's fair to say that as of today, there's no consensus. There have been a number of efforts on working groups, some of which have been with the industry, some of which have been with consumer protection groups. Given the political divide in the United States today, it's hard to bridge the gap on this. I think there is a commonality in there needs to be some sort of regulatory mindset around this, but I don't think that there's any consensus yet as to what that should be. So as you see on the slide itself, there's been these frameworks with Senator Schumer, who obviously leads the Democratic Senate, and there's been AI hearings there. It should be former House Speaker McCarthy had an education effort in 2023. Obviously, today, if you're thinking about what happens in the next week, the U.S. political system is completely paralyzed with the House not taking actions. In light of that, one of the things that has occurred, although not binding, is that the White House, the Biden administration, has been working with the top AI companies, and they have issued this blueprint for an AI Bill of Rights. Again, this is voluntary. These are not regulation. This is not law from a U.S. perspective. There is probably a question as to whether or not if a company makes a promise regarding the Bill of Rights, how enforceable that is in the private sense. But as a practical matter, the blueprint right now is not an enforceable thing. But the blueprint has, I think, a good outline of what are the considerations that are out there. And the 5 principles, which is really the heart of the blueprint, are as follows. The first one is a safe and effective system. And that's just, as it states, is the system, does it make sense? Does it safe for people? Is it doing something that could cause harm to people? The second piece would be, as Bennett was talking about with bias, et cetera, is there any algorithmic discrimination protection? I think it's important to understand, and we'll talk about this both on the compliance side when we get there, but even now on the regulatory side, this is the issue that people understand at this point. And so when you see what is the regulation, what are legislators, what are regulators thinking about, I think the first thought that they're thinking about is this algorithmic discrimination because it's very tangible, it's very understandable. And it fits within some of the already US regulatory framework. The next is there appropriate data privacy? And this is really an agency over your own data. Do you have agency over how it's used? And then in conjunction with that, are you getting a notice and explanation of what the system is using and what it is doing? There's a transparency element here that is sort of the premise behind all this, because everybody is fearful of the black box syndrome. And so what they're trying to do in the principles is to open that up and making sure that there is, in effect, consumer notice. That has been a hallmark of a number of efforts within the US in many contexts. One can argue whether or not the notices are effective and people read them, but ultimately from a protection perspective, from a principles perspective, they're looking at that. And then finally, the last principle is there a human alternatives and considerations, and is there a fallback? In essence, can someone opt out? And there is a caveat to that where appropriate. And so there's still a hesitancy built into the principles as to whether AI systems should be mandatory in the sense of no one can opt out. So in Bennett's example of the insurance company who uses an algorithmic AI can someone call up on the phone and say, hey, I don't want you to do that. I want to go back to the way it was, where there was some guy sitting there who's an actuary looking at my specific piece and underwriting the specific insurance premium. And so those are the 5 principles that are out there. That's voluntary for the main AI companies. There is no law that says you have to follow these. The second thing I think from a perspective, before I get to the joint statement, is we were talking about at the federal level. And one of the things that we've seen as a dynamic in the United States is that when the federal level cannot act, and we've seen this in privacy laws in particular in recent years, key states will opt in. And so one of the things, as you're thinking about risk and you're thinking about what is the risk of where you're going, especially with impacts in the US, and that is really, is there a state regulatory piece? So keep your eye on the feds, but states like New York and California can be very active when there are voids at the federal level. And so you need to take a look at that. And then one last piece that is not new, and that is there are a lot of laws on the books in the United States. And some of them are 100, 200, 150 years old. And what we have seen in the United States is taking laws that are old laws, but applying them to new technologies. So one great example is in Illinois, there's a statute about that basically was a fingerprinting statute. And so when you have facial recognition or you have fingerprint access to pieces, that statute, you have clever lawyers now applying old statutes to new technology. So don't take the absence of new regulation to mean that products are not going to be regulated or at least subject to litigation risk in the United States. Now, sort of talking about sort of what the US government is doing as of now, and what has been out there from more of an enforcement perspective, as opposed to a new regulation or policy perspective. And what you've seen is with this administration in particular, is a very consumer-oriented approach. And that's their stated priority. So when you look at the agencies here, the Consumer Financial Protection Bureau, DOJ, EEOC, and the Federal Trade Commission, they view their missions as consumer protection in the first instance, especially in a Democratic administration. And so when you look at the joint statement that was issued by these 3 regulators who have enforcement oversight, they're really looking at 3 different items. The first is, was the data into the system flawed? Secondly, is there a lack of transparency? Is there a black box syndrome so no one can understand what's happening? And finally, what I would call use cases or creep. Was the product inconsistent with the developer scope? So did the developer do one thing and then the company did something else, so it's not acting as intended? And again, I think this is very reactive to what Bennett was talking about from algorithmic. When you talk about the EEOC, you're talking about, is there discrimination in employment? In Consumer Financial Protection Board, I think the example being, is there something that is changing the pattern of consumer lending, for instance? So I think you'll really see this consumer side protection from the U.S. enforcement agencies. And with this administration, when you look at like the FTC, for instance, they've been very aggressive in enforcement. So for instance, the chair of the FTC in the competition area, they have taken positions and said they're okay with losing as long as they're taking an aggressive position to move the law. And I think that you will certainly see from a U.S. perspective, enforcement perspective, especially if there's in the next year and that there's 4 more years of the Biden administration, I think you're going to see test cases and you're going to see the enforcement agencies taking some positions to try to make political points, to make and to really protect consumers. I'm not going to talk about international. I think everybody should, although, be cognizant of some of the international. I'll let Bennett talk a little bit about that, but clearly the U.S. centric is only one aspect of that.
Thanks so much, Brian. I always learn from your perspective on things. And just on the global front, before we turn it over to Ryan for the Canadian developments, we are tracking more than 800 policy initiatives around the globe. And it's interesting to see what has legs and what doesn't. The EU AI Act is by far the farthest along. It takes kind of a risk-based approach, which we kind of like. And so there are prohibited uses of AI, there are high-risk areas and low-risk areas. And the higher the risk, the more controls and disclosures and things you have to have in place. That piece of legislation is in the trilogue negotiations right now. There's a lot of kind of infighting going on. Some member states want it more strict, some want it less strict. And so that's going to go on for a while. We don't think it's going to come out of trilogue until the first of the year or so. And even if when it does, it's not going to go into effect till 25 or even 26. So what we're telling clients is prepare for this with this kind of risk-based approach. And we'll talk a little bit more about that. What are high, medium, and low risk use cases in your company for your industry? And how do you put controls in place that are reasonable? Because that reasonableness standard is about the best we have going on. There has been legislation passed in China, which is difficult because one of the dangers it guards against is that does AI, especially generative AI, somehow undermine socialist values. That's a pretty open standard. We see things, there's another initiative in Brazil, which is much like the EU AI Act, a risk-based approach. We don't think, just like in Washington, we don't think anything major is going to come out anytime before the 2024 election. And these other developments around the world, we think we're 2-3 years out easily. So what that comes down to is how do you move forward in a space where the regulation is still unsettled? And we'll get to that. But I'll turn it over to Ryan for what's going on in Canada.
Thanks so much, Bennett. And yes, a great segue into the Canadian side of things, because that's exactly kind of the approach that the Canadian government is taking. We are probably a number of years away, probably a couple of years away from what this slide is talking about, which is the Artificial Intelligence and Data Act, which is right now in committee after its second reading. And it's part of Bill C-27, which is a larger update to our privacy legislation. Although it does create a separate act that is not privacy focused and is focused a little bit more on some of those kind of principles-based approaches and risks-based approaches that the other two speakers were talking about here. So the first, this is going to be the first kind of regulation of AI in Canada, apart from the way that, as Bennett mentioned, as Brian mentioned, there are other laws that apply that have always applied to AI. So, for example, human rights law, you can't just say, well, I used an AI and so I can avoid human rights law. However, this is now regulation that is actually focused on AI in Canada. It's very broad-based. It's not just generative AI, it's all AI systems. And the purpose is to establish kind of common requirements in Canada for the design, development, and use of AI systems. It will prohibit certain conduct, but more importantly, it will also kind of require certain conduct. AI is very broadly defined. It has to have kind of 3 features to meet the definition under the Act. It has to be technological in nature. It has to either autonomously or partly anonymously process data through the use of some sort of, AI-like algorithm. Bennett would probably speak more to whether we got the definition right. I've heard that in committee they are going to be talking about revisions to update this to the OECD standard of definition of AI, but this was the Canadian attempt at it. And then the last is, it has to generate content or make decisions. So this is kind of the 2 types of AI that Bennett was talking about earlier. You have got these kind of classification type AIs. They are caught by this, and then of course the generative AIs, they are also caught by this. So go to the next slide. The framework essentially applies to all AI systems, and it contains general obligations, whether you're the designer, the maintainer, the offerer, the user, and not the end user, but the person that's using it in your business. Generally, there is an overall obligation. Again, this did come as part of a privacy piece of legislation. There's an overall obligation to make sure that data is anonymized and handled properly in accordance with regulations that have not yet been published. And there are more obligations that will apply if something is a high impact system. And that's a definition that they've created for the purposes of essentially, in my view, probably trying to find a constitutional or a Constitution Act justification for taking federal precedence over this type of legislation. So in high impact systems, they have to meet certain criteria that are going to be established in regulations. Again, those regulations haven't been published, but there was a companion paper published that suggested the criteria they're going to be looking at. So is there evidence of risk of harm to human health and safety, an adverse impact on human rights? Is there some sort of severity of those potential harms? The more severe those harms could be, the more likely it's a high impact system. What's the scale of use? Is it going to be used in a narrow case or a very broad-based case? Going to what Brian was talking about, one of the things that's going to determine whether it's high impact or not is the extent to which participants can opt out. If someone can't opt out of a system, then it's more likely to have a higher impact than something that people can opt out of. The nature of the harms obviously will impact that. If there's some sort of imbalance of socioeconomic conditions or the age of the impacted persons, and then the degree to which there is some other law that already applies. So, for example, banking systems are going to be still largely regulated by, our various banking acts and not by this AI bill. For the next slide, we have developments that have happened since this bill's been introduced. So just on October 3rd, so a week ago today, there was a letter from the ISED minister, from the Industry Canada minister, to the standing committee that is now looking at the legislation in the Senate, and they're proposed they've said that people have said that these criteria are going to be difficult to apply in practice. And so what we would like to do, instead of having people kind of evaluate on themselves whether or not it's a high impact system, we would like to create enumerated classes of high impact systems that if you are one of these things, you will be a high impact system, taking into account those factors. So employment related decisions, service provision, interestingly that includes whether to provide the type or cost of provision or the prioritization of the provision of the service, which to me touches on things that are, I think, a little bit broader than what I would have thought prior as a high impact system. Biometric processing, in a number of jurisdictions around the world, we see biometrics being a big part of privacy concerns. Online content moderation, prioritization or presentation of content. This is one that's going to end up catching just about everybody, because AI tools are pretty much the only way that modern technology companies that have any sort of user-facing side of it can actually regulate the billions of interactions that are happening. So again, I think that this is going, if this stands, this is going to have a bigger effect than maybe intended by this government, although who knows. Of course, healthcare, law enforcement, court administrative decisions, these are all things that we would expect to see in these types of enumerated classes. But the idea is to have these classes so that we're taking the decision making about whether you have an AI system out of the hands of the proponents of the system and into the hands of some objective standard. Of course, they also left themselves some wiggle room. If you do have a high impact system, so why do we care? Because if you do have a high impact system, I think this is very consistent with the kind of voluntary stuff we're seeing happening. For example, the Biden administration in the US, as previously mentioned, and the voluntary code in Canada, which we'll get to in a second. You have to take some steps, and there will be teeth to this law that make you take these steps. Basically, you have to identify, assess, and mitigate risks of harm or biased output. Again, going back to the risks that Bennett was talking about, this act ignores the IP problem. This act solely focuses on the bias and the harms that could come from inaccuracy problem. They want you to establish measures to monitor whether those mitigation measures that you've taken in the previous step are actually implemented properly, and maintain records so that they can show that these things have happened. You need to publish a plain language description of the system, including how it's used, the type of output, the type of decisions it makes, and you need to describe those mitigation measures. And then because of the penalty making powers that we're going to talk about next, they also want you to notify the government if the system or the use of the system results in or has, an incident has occurred that is likely to result in harm. And I'm sure when we open it up for Bennett, he's going to have a lot of talks. He's got a lot of things to say about those goals and making them mandatory. So we will care about these because in the kind of typical post-GDPR world, for those of you familiar, GDPR is the privacy regulation in the EU that essentially it started this worldwide idea that governments could pass penalties that relate to some percentage of global revenue. And we've seen an arms race since then of all these legislation coming in saying we can take a cut of your global revenue if you get it wrong. So it makes people pay attention. And I think that's why governments do this, because a lot of people paid attention to the GDPR for that very reason. So on the criminal side of this act, we will have 25 million or up to 5% of your global turnover is the potential penalty if you violate those aspects of the act that will be determined. On the administrative penalty side, we don't know because they say it'll come in the regulations. I suspect it will follow the privacy side, which has like a kind of 3% and 5% gradient, and a 10 million and 25 million gradient, but who knows? These are significant though. These are designed to get your attention. The last thing I want to talk about on these developments are, because this is so far in the future, we kind of have to or the government right now is trying to wish cast the amendments that they want, and what they want companies to do in the meantime, because they recognize that it's probably, as Bennett said, we're probably 2025 before this even comes into effect. We haven't seen the regulations yet. It's still not out of government. It's still being proposed. It's still in draft form. It's at a committee. So we're a number of ways away. So they're signaling to the world what kind of amendments they want. And the first big thing that you may have noticed in the earlier parts of what I talked about is the AI bill basically missed generative AI entirely. It came out, in early 2022 when it was first proposed. Generative AI was a thing, but probably not as publicly known of a thing. And of course, since then, generative AI is pretty much what everyone thinks about when you say the word AI now. So one of the things that they want to do is to add distinct requirements for language learner models and other quote unquote general purpose systems that have uses in many different contexts. So again, it's similar stuff, but they kind of recognize that it might be hard to call these high impact systems. So they kind of want to create a parallel system. Many of the same obligations: impact assessment, assess and mitigate risks, have a plain language description that kind of describes what you're doing, monitor it, report serious incidents to the AI developer. So if you're using an AI, say I'm using ChatGPT and something goes really, really wrong, this is going to presumably require me to notify both OpenAI as well as the government, which is an interesting legislative move. Take steps to inform users if they could be potentially fooled that they are dealing with an AI. So this is probably designed a little bit of consumer protection, as Brian was alluding to earlier. The last one's going to be super problematic from a technology perspective. So they've kind of softened it with best efforts, but they kind of want companies to develop their AI, their large language models, to make sure that there are some efforts made to make sure that AI generated or AV content can be text or AV content can be identified as AI generated. I think that's going to be really difficult in a world where Adobe Photoshop has an AI tool built right into it that millions of people can access, but let's see. For the last slide here on my section, again, we're far out. So what the government did in the meantime is they've released, after some consultations, they've released what's called a voluntary code of conduct. I don't need to really go over this because it is highly modeled after the Biden the Biden joint declaration of the 7 companies. What I will say is that unlike the Biden administration, they released this without any signatories saying, if you would like to sign up to this, please do. And it contains many of the same things that we talked about earlier, but to my knowledge, did not start out with 7 signatories. And the 7 signatories to the Biden one, are the main ones. They're the ones that, most everyone are using. So it remains to be seen whether these companies are looking forward to the prospect of going to every country in the world and signing up to various different voluntary codes of conduct. Some of them may take the perspective, hey, we're complying with this, but we voluntarily agreed to this one in the US. It's good enough for you in the rest of the world. We'll see how that goes. Anyway, that's my talks. I'll turn it back over to Bennett.
I think it's actually to me. on this. So now that we've scared you, and now that we said, here are all of these risks that are out there, I think the real question is, from a GC, from a chief compliance officer perspective, what do you do about it, right? You can't put your head in the sand. You've got to be affirmative. You've got to take reasonable steps to protect your business, protect your company. And from a US perspective, you start with what I would call the DOJ, the Department of Justice, elements of a compliance program. Because when you have an effective compliance program, in essence, the modeling in the US is that you should, quote, have a get out of jail free card if something goes wrong. Have you taken those reasonable steps? It's also from a more corporate governance perspective, if you think about from a US, Delaware law, which most corporations fall under, there are a series of case law which requires boards of directors to exercise their fiduciary duties consistent. And one of those is doing risk mitigation and having a compliance program. So if you start to think about what goes into a compliance program, it's really a cycle. And so if you start, the first part of the circle is a risk assessment. And then you come into, once you know your risks, what are the policies and procedures? How do you then do training or communications to folks? And then what's the auditing and monitoring to make sure that the processes, the procedures, et cetera, is put in place? And so I think the key here from where we are today starts with that risk assessment. And from that perspective, this is a changing environment. And what you did 2 years ago, if you were a chief compliance officer and you performed a risk assessment 2 years ago and you looked at, one, what regulations and laws apply to me and what is the litigation risk, you're going to have a different and now you have AI within your products, you're going to come up with a different answer today than you had 2 years ago. Even though functionally, if you think about it, say, I'm a life insurance company and I'm still selling life insurance, so why would my risk be different? Because now you've changed the underwriting process. And so therefore, what's going into the product is changing your risk profile out into the public, even though, quite honestly, in that example, the product is exactly the same. So you really need to start with what is that risk assessment? Changes in law, obviously, then places there's going to be changes in product. So if you're a company and you're now changing how you're interacting with consumers online and providing information, instead of having a customer service person on the phone and you're using AI to respond to that's changing your product, and that's going to change your risk profile. So you need to understand not only the changes in law, but is there something, either a new product we're putting out or changes in the elements of the product that we're doing out to the market? And then finally, what are the controls around it? And so when you think about, okay, there's these changes, but if we're looking at the same regulatory compliance, so I'll take my life insurance example, and I have a bunch of people who are saying, are we applying with insurance regulatory law? I'm going to miss that we're doing something different in our products, which puts me at risk of laws that are outside the insurance regulatory law environment. So you need to understand, what are we doing to control these new products, and and make sure that we have the right testing, the right that's there. So you start from that risk assessment. I think in rapidly developing companies where they are where you're putting in new products, where you're changing in the laws, you should be doing this fairly frequently, because it is a very dynamic environment. When you start to go around that, obviously your risk assessment is going to inform what are the policies and procedures we now need to put in place. Now, as we talked about in where we're going, those policies and procedures are a little bit ill-defined because you don't know what the remedies are, but you need to put them in. You need to make sure then that your people understand them, and then the monitoring and auditing. And so if you turn over to sort of specific to AI, and this is really what I would call, from a product development perspective, that governance stack, you're really starting to figure out, how do you put controls around this in order that as you develop, you're having an acceptable level of risk. And that's fulfilling both directors' fiduciary duties and just generally from a making sure that you're comfortable with where that's going. And so when we think about the governance stack, you start with sort of what's the council, what's the charter. You need something that kind of grounds the whole program. And where are we going to do that? Just like in privacy, if you think about it, and I know we've used a lot of comparators to privacy, if you don't have a centralized thought process and policy and group with people with knowledge, and so this council, and then a shared understanding of what's the risk tolerance, what are we trying to do, we are not going to start with an effective governance way to mitigate risk or to get to a risk level you're there. So the first thing is to have a really concerted governance structure and a concerted set of leadership with instruction that's there. Once you get that, you're really going to start to say, what are the policies? What are we going to do? What do we find to be acceptable for us? And who needs to sign off? So that, I mean, the biggest risk is someone says, hey, this, someone in the tech world says, hey, this is really cool. I'm going to just stick it in and it's going to be awesome and people are going to love it. And then 3 years later, someone goes, why is our lending disproportionate into higher wealth areas that are in the US, not minority? And you go, I don't know. And you go back into the tech and you say, oh, wow, someone put this in there. So you really need to think about making sure that you have a policy on how this is going to be utilized, how it gets integrated into the products, and that. So you start with your policy. Then a risk matrix. The company, based on your product, based on your risk appetite, you really need to understand what are you in the market for? What is okay and what's not okay? So you're going to do that. That plays into the risk assessment we've talked about because you got to understand those risks. But you really want to make sure that you're understanding and putting risk at a level that's acceptable. From a U.S. perspective, if you think about it from a litigation world, the likely significant share, if something goes wrong from a shareholder litigation perspective or securities litigation perspective, it's going to be around, did you actually consider the risk? Did you put this in place? And that risk matrix is going to be key. And then finally, I think a very organized way for a use case approval process, which kind of runs through all of this, right? Is the right person making the decision? And is there a thoughtful decision on how we're going forward? I think where companies get into trouble is where things are decentralized and it's a surprise to other parts of the organization that something has been put into the product that you don't see. So I think there you really want, just like in the privacy world where you may have breach protocols on who's going to do what and how you're going to do that, you're going to want that here. I want to pivot for 1 minute because I know that we've got some chief compliance officers and people thinking about compliance programs. So the other part of this, right, when we talk about sort of what's that cycle of compliance, what are the elements of a compliance program, is there is an opportunity here from a compliance officer perspective. There are tools that are going to be coming down the pike. There are ways to use these AI products that are going to strengthen your compliance environment. So don't think about it only in the negative risk piece from a compliance perspective. The question is, how can you use this technology to better strengthen compliance? And one of the things I would think about is, when you think about like in the financial services, is there a more efficient and better way to look at transactions for suspicious activity? When you think about in the anti-corruption perspective, can you do AI across vendor payments, for instance, and see, is there changes? Is there something that's going to tell you, we signed this vendor, it seems really out of the ordinary based on the data. Maybe we should go look at that vendor. There's brand new guidance that came out last week in the US from the Department of Justice, which has said that if you acquire an entity, you now have a safe harbor that if you self-report compliance issues within that safe harbor, then you in essence get a get out of jail free card. And so when you think about from an M&A perspective and where compliance sits in that, can you put tools over the acquired entity to identify issues that might come up? So for instance, the DLA, we have a product called Ascension, where you can actually use an AI type product to go through someone's historic email. So if you acquire someone and say, hey, is there a competition issue? Is there a bribery issue? But these are the kind of things that you need to start thinking about from a proactive perspective as a compliance officer, because there is a lot of opportunity here. So back to you, Ben.
Yeah, Brian, I'll pick up on that point because it's really quite interesting. If you look at what all these AI systems do, they look for signals in data, particularly about human behavior. And so we can find who's going to react to this treatment better, education, risk assessment for underwriting, for insurance and credit risk, who's going to click on an ad. But you can also look for violative behavior in your company. One of the things that we have built and are building for many of our clients are what we call predictive compliance systems. So think foreign corrupt practices, anti-bribery, anti-kickback, general fraud. You can detect patterns of situations that are going south and intervene before they go south. And you can certainly identify compliance issues much more quickly. So all of this, so let's just distill down everything we've heard, right? So one is there's two basic AI systems, the old-fashioned classification systems, which are like 99.9% of the ones that are in place out there, and then generative AI systems. They both have strengths and weaknesses. They're great tools to bring into your organization. But everybody in the world is worried about how these things are going to get governed and regulated. And so, but you'll see this common trend across all of them, as Brian talked about. It comes down to identifying the risks that you're introducing into the market by your use of AI and reasonably mitigating those risks. That reasonable to standard is the bedrock of all of these risk-based systems, ideas around transparency, explainability, reliability. All those standards are pretty common across these global regulations. And we also want you to understand, you know how to do this. Your company does stuff, right? And you know the steps that it takes to do that stuff, and you've got controls in place around those. So it's not, you don't have to reinvent the wheel here. What you have to think about is, how does my introduction of AI into the creation of that product or service change my risk profile? Accuracy, bias, explainability, reliability. And how do I put controls in place to measure and mitigate those? The cool thing about AI is that it's a technical solution. And so when you're approving the use case, approve controls, technical controls that monitor and measure, scientifically, statistically measure the things that you're trying to guard against, and spit out the metrics that prove that you're being compliant, whether it's your own policies or developing regulation. And that brings us into this idea of use cases. So we are working with dozens and dozens of companies around the globe in every industry on, how do I bring AI into my company? And the important thing to understand is that there are certain things that AI does better than humans, and there's things that humans do better than AI. The key is to understand the difference between those things. And so, like I said, all of us in every industry, we do stuff, and that stuff has steps. Well, some of those steps are AI optimizable, and some of them are quintessentially human. So it's important to understand the difference between those two things. And what we tell our clients is, think Iron Man, not Terminator, right? So everyone asks us, are lawyers going to replace me? Or is AI going to replace me? No, but it's definitely going to replace certain tasks that you do. So it's not like a robot's going to replace people. It's more like Iron Man, where you've got a really smart individual who you augment and extend their capabilities by surrounding them with enabling technology, right? So it's much more a hybrid in most cases than it is a replacement. And so the places we're seeing AI be put to the best work is how you develop your products, whether it's a product or a service, R&D, and understanding the steps and economies and efficiencies of a particular process. We are finding that to be a really rich place for AI, especially Gen AI. And this is because Gen AI is different than the classification models. The classification models are built on very firm, solid statistical principles, but they're also bounded by those principles. What Gen AI does is it finds patterns in language or anything else. And it finds patterns in ways that we humans don't think about, but also that our traditional statistical models don't take into account. This is why we're finding, like in life sciences, new proteins, new molecules, new gene sequences, because it's finding patterns that we haven't been able to detect before. The other place it's really interesting is in your existing process optimization. AI is better at identifying, collecting, summarizing, and analyzing data. So in the steps of your workflows that include those things, that's where you put the AI piece, right? Anything that's highly repeatable and data centric. We're finding this, for instance, one of my jobs as chief data scientist is to bring AI into the firm. It turns out that lawyers do a whole lot of identifying, collecting, analyzing, summarizing data. So we are finding incredible efficiencies in bringing generative AI into the creation of our legal products and services. And it has a huge impact culturally on what we're doing. Other use cases we're finding are enhanced customer experience. So you're seeing a lot of people pushing out kind of GPT or Gen AI based bots, right? Because customers ask the same questions over and over, where you can spit out an answer that is accurate 100% of the time. Same with internal use cases. So ask HR or right IT, they get the same questions. And so what we're finding is that Gen AI out of the box is incredible. It's this incredible tool, but it's also kind of in its toddler stage, right? Like we're all amazed when our infant children take their first steps. We're like, oh man, that's incredible, right? But they're still not very good at it. Well, that's the kind of stage we're at with Gen AI, right? It's at this very beginning stages, but where we're finding the most impact is when you take Gen AI and combine it with your existing technology or data. For example, you can take Gen AI and just a basic model. And so think of it's gone to World College, right? All that stuff's in its head. And you can fine tune it on an additional subject. So like there's many legally trained AI systems out there now. One is called Co-Counsel by Case Text. Harvey is one. Both Thomson Reuters and LexisNexis have trained AI. In fact, Thomson Reuters just bought Co-Counsel. And so think what that does is it takes its legal knowledge and elevates it in the stack of stuff and the answers it should return. Well, in the same way, you can take a basic LLM and point it at your data. So like in the law firm, we're creating baby bots for each of our practice groups. So we've got decades of content that we've created on particular subjects, labor and employment, transactional, restructuring. And by taking an LLM and pointing it at our labor and employment data, I now have a compendium of everything that we've said over the years, and I can ask questions and create more consistent, easier, more efficiently created legal products and services. So that's the thinking, is how do I harvest what my company has created and take the LLM and send it to my company grad school. So the last point before we open it up for questions. This is the most transformative and the most disruptive technology since electricity. And we are at the very beginning stages of this. This is going to change how we do business, how we interact with our employees, our markets, our regulators, our legal system, our interactions between citizen and government. And if you look at the second industrial revolution and when electricity was commercially distributed, it had an immense effect, not only on every industry, but also all those legal systems, government systems, markets. It's important to understand how this disruption is going to affect your company. It is absolutely predictable. And so thinking about how is this going to impact my workforce? What skills do I need to invest in the future? How do I adjust my stack to lean into that curve? Think about how your customer experience is going to change. And how can I leverage efficiencies with Gen AI to gain market advantage? And lastly, it's kind of easy to stay ahead of the regulatory developments. They're slow, they're transparent, we see where they're going. And so setting up this reasonableness kind of risk management approach will allow you to react in time to any particular movement in the regulatory space. But it also, there's a great opportunity to actually get involved with shaping regulation. Every regulator in the world, and we have been interacting with dozens of them, the first thing they do is they go out there and say, hey, what are you doing? And what are you, they have stakeholder meetings, they gather information, they hold hearings. And so getting ahead of this and how you're going to govern it and what challenges and opportunities it provides, and being able to communicate that to your regulators and legislators actually has an increased impact on shaping good, solid law that's both good for you and for the markets. So we want to leave you on a very positive note. This is amazing technology. It's going to change everything. How we, the biggest challenge that we find is very successful companies who try to defend how they have historically been successful are going to be behind the eight ball. Companies that are willing to think larger and sacrifice maybe the way they've always done things and think about how this can supercharge them are simply going to move ahead. What we say to our clients is that companies that don't predict, understand, and implement this technology are like the dinosaurs the day before the meteor hit. They're extinct. They just don't know it yet. So stay ahead of that curve.
Perfect. Thank you so much, Bennett and Brian and Ryan for your insights and for your comments. Extremely helpful. I'm looking and I don't see any questions that have come through the Q&A section yet. And so I had a couple of thoughts or points for further discussion. Before I jump into that, I wanted to quickly remind everyone that is tuning in right now that as part of this symposium on Thursday, at the same time, we have a very interesting and important topic on crypto scams and new regulations related to cryptocurrency. And to register for that, you would simply go back to the same event webpage. And so please do check that out. And then just pivoting back to our discussion, I'm going to start off with something very basic. Black box syndrome. For those of us who don't know what that term is, I saw and I heard Brian refer to that a couple of times. Brian, do you mind describing for those of us who aren't familiar with that, what that is exactly, how it is a pitfall and how to avoid it, just at a very high level?
Yeah, so if you think about it from like a GC or a compliance officer perspective, and you say, and you take the position that I'm only going to look at the end product. So I'm only going to look at the very end of the chain when it says this person should get a loan. And I don't understand, how did we come to the determination that this is the right person from an underwriting perspective, from a risk perspective, that this person should get a loan? But what I'm really saying is, yeah, I trust the system. It's a system, and there's no harm in a system doing that, because I don't understand what is underneath that. What are the considerations that are being used? In the old days, you go and ask the underwriter, what did you consider? Here, you've got a system that doesn't respond back, unless, of course, it's doing language. But now you really need to, I think from a GC and from a chief compliance officer perspective, is to ask that next question. How did we get to the end place? I don't want to just say, hey, it came through and I'm going to evaluate the end, because it's how you get there that actually can matter. And certainly, as you've seen in the principles and things other, that is one of the primary considerations of that the regulators are looking at, not only from, is it fair and is it coming up with a good answer, but is it visible to the consumer or to the person who's interacting with the system So they understand what is happening to them or to their data at that point. So I think that's really how I would think about it. And I would think about it from the GC, CCO perspective is don't put your head in the sand on how you got there and only look at the end product.
That's a really interesting point, Brian, because with these recommendation systems, which is again what most of us are using today, you can actually measure that. Like you can figure out every one of those variables, those data points that are in that classification system, you can tell what weight they are giving to the final answer. And what's interesting with recommendation systems, monitoring for unintended consequences is fairly easily done. We monitor and test algorithmic systems for clients all the time. What's interesting with Gen AI is it's unexplainable. And so even with all these regulations that are coming out, the explainability piece is just going to get harder and harder. And so the focus is going to go on that output testing, meaning this stuff results in some decision and that decision has an effect that I can measure. And so the focus on how do I measure the impact of the decisions that this is making? And so it depends a little bit on which of the two AI systems you're using, but there's always a way to figure out where you touch your employees, the market, a consumer, whatever, right? And so that piece is what the regulators care about, and having measurements around that is really critical.
Okay. We do have some questions that have come in, so I'm just going to pivot to those. One question, what recommendations do you have on the governance side for companies to guide employees using publicly available Gen AI tools? Any red flags to avoid or high-level do's and don'ts advice? And I'll kind of open that up to any one of you, whoever wants to jump in on that.
I'll start on it. I'm sure all of us have thoughts on that. I'll start just by saying that to a large degree, these Gen AI tools are functioning more or less like the cloud tools we're all used to when you use them in the typical way that consumers and businesses start to use them. You log onto a site, they have terms and conditions that apply, they have privacy policies that apply. It's a foreign site that you need to do some vetting on, particularly if you're sharing data. So for sure, I would say you're starting with at least your traditional cloud-based computing policy, making sure that you're vetting the vendor, that you understand how your data is going to be used, that you have controls in place so that you know where and how people are using it. But I think that the red flag for me is don't assume that if you publish a policy saying you can't use AI in your business, that's going to work. It's not going to work in the year 2023. We have to assume, I work with video game companies a lot. Game companies have to assume that to some degree, a writer might from time to time just get a little bit of help from ChatGPT, right? They can't just pretend like that's not going to happen. They have to absolutely build policy around the fact that if you're going to use it, here's how you safely do so, and what policies and processes are we putting in place internally to make sure that we're making that we understand how it's being used and that it's being used properly.
And just as a follow-up to that, sorry, go ahead, Bennett.
I was going to say that it really is a big divide between the consumer-facing publicly available ones and an enterprise license. With the consumer-facing ones, they're great for certain things, right? But you really can't put company confidential information in it, PII, because you just don't have the controls or protections under the term of service. It's great for summarizing general stuff, coming up with an idea, right? But you really have to limit the public facing side to very minimal kind of use cases. We strongly urge every company to get some enterprise licensed version. They're widely available. They're not that expensive. You can get them through Microsoft Azure, through AWS, directly with the companies. And as soon as you have an enterprise license, you get all the stuff you're used to with any other cloud-based license.
Okay.
And I think, sorry, the one thing I would say here is, and I think it's to Ryan's point, it's one of those things where you can't stop people from doing it. They're going to go onto ChatGPT and say, hey, what does a normal sanctions program policy look like? And they're going to get something back. And so I think it's really important. Silence, I think, is going to be deadly in this space. I think you do have to set out expectations. I think for the reasons that Ryan and Bennett were talking about, certainly from a licensure perspective, et cetera. But also, I think you want to make sure that in the worst case scenario that you do have someone who goes rogue and does it, and you don't know about it, goes in there, you can point to a policy and say, hey, that person shouldn't do it. It's got to be reasonable. It's got to be enforceable, because you can't just say, hey, in today's world, we're not going to let anybody use email, right? That's just not going to work. Right? How do you use email? How do you use
Right.
AI? And that's really, I think, where you've got to start with that premise there.
So this is a related question. I think it's been answered to some degree, but we have a question here that says, where does a company start to include AI in their compliance program? So a little bit more of a practical kind of inquiry. And so I guess I'll put that question again to all of you. Aside from hiring DLA to help you with this, where does a company start to include AI in their compliance?
Well, I'll start with that because I think I introduced that as we were talking. And I'm going to start it with a little bit of a non-answer at first. It depends on what your company does. A financial services company is going to be different than a manufacturing company that's going to be different than a professional services company. So I think the first thing is you got to start with, okay, what are we doing? What is the company? Because if I think about it like from a compliance program for financial services, can you put some sort of AI product over top of your sanction screening or your AML transactions, right? Pretty obvious. But I think if you're in different industries, you're going to come up with different answers. The one commonality I think that is out there, and that is to the extent that your compliance program is doing investigatory work, and whether it's whistleblower complaints coming in, hotline complaints, et cetera, there are lots of opportunities to put AI there to get to better results faster, quicker, cheaper. So that's probably a pretty quick win. That's not industry, it's industry agnostic. But I think you're then going to look at what are our risks and how does AI fit within those risks.
Yeah. What's really, really interesting about what especially Gen AI can do is it's very good on what we call unstructured data. So email, chats, things like that. The compliance space is pretty saturated in what we call the structured data space. So think spreadsheets, numbers, rows, and columns. So think transactions, vendor payments, expense reports, time records, all that stuff. Old-fashioned classification AI helps in compliance in that space. But the problem with that is that's only catching a problem after it's happened, right? A transaction that is bad has already violated something. What we have found with people's email chats, communications, is that there are always indications of something about to go wrong before it actually goes wrong. So we've built and helped companies build what we call predictive compliance systems. We used to call them Minority Report, but apparently that's a thing. We couldn't do that. But think like anti-bribery. Well, there's only certain people at the company who can engage in that behavior, and it is defined by communications and transactions with certain kinds of people. Well, those can be isolated and automatically monitored. And so it's various, I think anti-kickback, Foreign Corrupt Practices Act, fraud, bribery, generally, all of that stuff is eminently detectable. So what we work with clients on is where is your biggest problem or risk? Where have you gotten in trouble before? Where have you find whistleblower violate? Like, what is it that is keeping you up at night? And can some monitoring system be designed to capture that, especially in unstructured data?
Excellent. Well, one of the points that I wanted to make, and I'm going to invite your comments on this. I'm looking at the time, one eye on time, and we only have about 7 minutes left. There's been a lot of discussion, and going about 2 slides back, I think Bennett touched on this, the idea of, taking data sets and feeding them into a purpose-built LLM, large language model, and then essentially kind of putting it through school or university and so I think we've had a lot of discussion about the algorithmic side, but there's another component to that, and that's the information that you feed, the data sets. And in terms of looking at where you begin with policies, one of the things that I think a lot of people and a lot of organizations have to be cognizant of is information retention policies, which I think will be precursors to information transfer agreements. And, there's a whole host of privacy issues that come out of it, but at a very basic level, I think it's important not just to have the compliance side with your AI program, your LLM, but what about the information that you've been gathering and harvesting? And what are you doing with it? And how do you store it? Are there confidentiality concerns? And then you go ahead and you pump that into the system, and then it's producing novel ideas, concepts, and information, identifying patterns and such. So it's also the information that you're harvesting for use. And so I think that's very important to kind of point out. And just as a lead off, before I pitch it back to you guys for the last 5 minutes on this topic of information harvesting, there's a lot of talk about de-identifying information or anonymizing those data sets, because of course, if you're a professional, a lawyer, in the insurance industry, banking, in the healthcare sector, you're collecting a lot of information, which has value. You have to strip it of the personal information, and then you can use it to identify patterns. That's called, anonymizing or de-identifying. So, circling back to kind of best practices and compliance with that information side, not just the AI. Any thoughts and practical advice for our viewers?
There's just amazing stuff that can be done with this technology. And so part of it is, like we talked about with the recommendation systems, what you stick into this stuff's brain matters, right? It already has a bunch of junk in there. And so understanding the data that you're pointing at it and really trying to point subject specific stuff into it will get your best results, right? It's important that you have legal access to the data, right? So if it's yours, if you're going and like you've seen all the cases going on in the US against the Gen AI makers about, hey, you scraped my stuff and made $1 billion and now I'm mad, that's going to get settled somewhere. But it's important the quality, the accuracy, the timeliness of the data that you put into it. And really the best way to control AI is with AI. So you can, there's this concept called constitutional AI. And so you can literally list, they're called meta prompts. You can say things like only pull the most accurate or most recent data. Don't use any personal information in any of your outputs. You can kind of almost like a constitution. Here are the rules that every prompt I put in has to run through these gates. The other is when you're worried about accuracy, bias, toxicity, we have found the most successful ways to do this is to pit AI against AI. So when we're using this for our own use cases, we write a prompt that goes to 2 versions, same GPT-4, but 2 instances of the model. It spits out answers, and then they argue with each other until they come to consensus, and that's what the user sees. Much more likely to be accurate, non-biased, non-toxic. So you can be super creative with this if you think through how to use the technology.
Let me be a little bit less sophisticated than Bennett, which I usually am. And I think, Imran, the point that you made is you do need to go, what is the source of the data that you're using? So if you're using your own customer data, not just, I know it's customer data, but it's EU customer data, or it's customer data that was gathered with this tick box on what you can use it for. Because as we talked about, pre-AI laws and legislation, whether it's data transfer, whether it's privacy notices, et cetera, still apply. And so I think, again, in the most simplistic sense is as you decide, hey, here's the data we're going to stick in, start with the first question is where did it come from and what if any restrictions are out there? I mean, in the US, as Bennett mentioned, we're already seeing the data scraping cases with the ChatGPTs and Microsofts and people of the world. And that's sort of the more general, you went through the internet and scraped everything without telling me. I think as you get into data sets which are much more specific, whether it's healthcare or whether it's employee data, where there are even more specific expectations of use, you're going to see more and more friction around that, whether it's in legislation, whether it's in litigation, et cetera.
Right.
I can put in just a very quick word. I know we're at a minute. I just wanted to say that this kind of actually ties into some of the previous questions too, about black boxes and stuff. One of the biggest issues with or risks with using Gen AI and AI in some cases is that you're not necessarily going to know what inputs it chose or how it develops what it develops. And so the provenance of your data kind of has to be taken from a global perspective, and looking at the outputs, we're seeing some companies run into some trouble where, they release a poster for a movie and someone says, hey, that thing looks an awful lot like something, some stock photography I took, or some, and do we know for sure that the AI didn't just independently develop that? Copyright is recognized for a long time that two people can independently create the same thing. But with AI, we don't know the answer to that. We can't really, unless we build the systems in a very different way than they're currently built. We can't really ever answer that question. There's no evidentiary trail to say here's exactly how it happened. So I think you have to keep that in mind when you're using these data sources, that there is going to be an inherent risk of the provenance of that data, even whether it's on the the large language that you're training it on, or even your internal data that you're feeding it in. You may not know how it uses that.
Okay, thanks so much for that. I think just some parting advice for the Canadian attendees is that on this issue of kind of information harvesting and kind of the gathering of information, in the absence of express legislation, as Ryan touched on, it's still kind of in second reading. We're years away from that, but in the absence of that, a lot of that information still falls under the common law requirements of confidentiality and also trade secret law, which in Canada are provincially regulated. And so it isn't the case.
And personal information law too. And personal information law. It's exactly right. We have very old, but still arguably applicable privacy law here.
Exactly. And so legislation, like I was going to say, PIPEDA, and so it is important to kind of get in touch with professionals if you're developing these information retention policies, because there is, however raw, there is a legal landscape there that is emerging. So, gentlemen, I think we are at a minute past our time. I want to thank all of you, each and every single one of you, for your contributions today and for your information and insights. Very, very helpful, very exciting. That's the thing about Gen AI is that at the end of the discussion, it feels like you're ready for another, because it's just 50 more questions, 50 more insights. So I think we'll have to save some of these questions for a follow-up. But I want to thank you once again for your insights, for your information. And thank you to everyone that tuned in and for your questions as well. We wish we could answer a couple more of them, but I think what we'll do is we might save that for a follow-up. So with that, I think we'll sign off and we'll conclude for today. Thanks, everyone. Take care.